Good morning, everyone, and welcome to today's webinar hosted by PYA. Today, we are continuing our Healthcare Regulatory Compliance webinar series with a presentation on So Many Proposed Rules, So Little Time. PYA is happy to present today's webinar on this important topic. You will have the opportunity to submit questions to today's presenters by typing a message into the question pane of the control panel. We will collect these and address them by email after the webinar. All of our webinars are recorded and released with a copy of the slides after the event. With that, I would like to introduce Martie Ross, Consulting Principal, and Kathy Reep, Consulting Senior Manager at PYA.
Thanks, Laura. We're going to go ahead and get started with the agenda for today. And we said that this would be so many proposed rules, so little time. And when we start looking at the idea of so little time, I think it's important for us to look at, on all of these items, the time frame for making comments and providing your feedback on these various issues. But then, in contradiction to the title of the program, where we said so many rules, we're going to start off with an update on the No Surprises Act. We will then talk about some changes for Medicare Advantage, issues surrounding prior authorization, healthcare attachment transactions. Martie will address non-compete clauses, rights of conscience, and the confidentiality of substance use disorder patient records. So let's kick that off with the No Surprises Act update. On the issue of the No Surprises Act, I guess there are really three things that we want to focus on, and then one little bit of news related to more No Surprises Act litigation. So first of all, on December 2nd, 2022, there was a FAQ published by this HHS addressing the issue of good faith estimates. And this is the response that I would say providers everywhere were hoping to get, even if they had to get it through legislation. But we actually got this as a response to an FAQ without requiring legislation. I think you probably all remember that we were expected as of January 1, 2023, that if we were the convening provider, we had historically for the past year been giving a good faith estimate for self-pay patients who were having services at our hospital. We had been told, or at our facility, we had been told by HHS a year ago that beginning on January 1, 2023, we would also have to be able to request and our co-providers, others involved in the care of the patient, provide to us their good faith estimate, and that we would provide a single good faith estimate to the patient, not only what we would be charging, but also what any downstream providers would be charging. If I remember correctly, they had essentially, we had a day to ask for that information, and then there was a day turnaround to have that information, give it back to the patient. CMS on December 2nd announced an indefinite enforcement delay. This is an enforcement delay. If you want to do this and get the information from your downstream providers, you're welcome to do it. But right now, it's an enforcement delay that is, my gut feel, going to be in place for several years, because what we're going to have is the establishment of an interoperability standard for transmitting that information. This is very important information that would be protected under HIPAA, and it's going to have to be transmitted between facility and provider. We're going to have to be addressing all the downstream providers, whether it be your surgeon, your anesthesiologist, pathologist, etc., and passing this information back and forth. CMS in their FAQ says that they are looking at the establishment of an HL7 fire standard application, but that's not going to be something that we're going to have overnight. So we do have a delay on enforcement, And this is, I think, a big win for a lot of providers who were the convening provider going forward. That was our Christmas present. And then lo and behold, right after Christmas, we got another FAQ from CMS. I would want to comment that this new FAQ, FAQ number 4, recognized that they are publishing all of the FAQs individually. It's not a single document that has all of the good faith estimate questions and answers. It's each individual document that you have to track down. But FAQ Part 4, which was published on December 27th, addresses what to do when you provide a sliding fee discount. I would like to say that this one was, thank you for this information. It is great, but I think it's also going to be a little bit complicated, harder to do. Because if you have a sliding fee discount and let's say your charge is $500 for a service, then your sliding fee discount is going to have to address various income rates and then what the discount is for those various discounts. They give that as an example. I think that one's a little bit difficult if you truly use a sliding fee schedule. If you are actually having a dialogue with the patient in advance and getting some information related to their income and establishing your discount up front, then you can just report your discounted rate. But if it's a sliding fee schedule and that's what you want to give to the people, I think it is a lot more difficult to pull that information together. But take a look at that FAQ. Anything on that one, Marty?
The only thing I would caution, Kathy, is you made reference that you, of course, are free to comply with the co-provider requirement, but appreciate that any exchange of that information needs to be accomplished in a HIPAA compliant manner, that you are never excused from compliance with HIPAA, even if you're excused from the enforcement of the No Surprises Act requirements.
Thanks, Marty. And then I would say this was not a gift from HHS and the other parties involved as it relates to the independent dispute resolution process. Every time Marty and I have done a presentation on the IDR process, we've provided this basic little workflow in terms of what happens on what day within the IDR process. But you can see that in red, we've put the major change. And this was essentially, don't think a lot of people caught that this had happened. Right, under the table, yeah. And you can see that what they did was that they have revised the administrative fee for the IDR process. So rather than paying $50, which is what it was last year, both from the payer and the provider, it is now a $350 administrative fee. But we have news from our friends in Texas. And the Texas Medical Association is challenging this significant increase that literally came, I would say, the last week of December, Marty, that we got this information that they had increased the rate for you to file an IDR dispute. Recognize that in many instances, the amount in controversy, particularly for some physicians, will be less than the cost to file the dispute. So if this was the idea to stop people from filing disputes, I can understand, but the Texas Medical Association has stepped in and has said, no, this is not appropriate.
Yeah, Kathy, this is so interesting to watch what's happening around this. I mean, and disheartening. Because the 7-time increase in the administrative fee, which you don't get back, that's separate and apart from the IDR entity fee, which is, another $350 to $700 on top of that amount.
Right.
If you're talking, if you're a radiologist, and it's more the volume of claims than the amount of each claim, typically, and if you're, caught in a struggle with the payers, and they're looking to push you out of network because they think they can improve, they can reduce your payments by pushing you out of network. you don't have a way to fight back because the claims are most likely under 350 and certainly under 1,000 in most cases. So every time you go up to bat on one of these IDRs, you're standing to lose even more money.
Right.
And the batching rules are so narrow, your ability to take multiple claims and bring them through a single IDR process. And those are very restrictive in terms of the nature of the claims that can be batched together. And by the way, don't forget, when you do a batch claim, the IDR fees go higher yet. So it's really setting this up to make this process not viable for providers to challenge the rates offered by payers on these out-of-network claims.
So we all need to say thank you to TMA. They've been successful so far on some of their challenges. So let's see where we wind up on this one.
Exactly.
Watch the
Yeah.
news. Okay,
Yeah,
now let's actually get into why we were originally planning to be here, and that was so many proposed rules. So I'm going to start with another rule, a proposed rule that came out again on December 27th. That was for those of you who are looking for something to do for the little Christmas break. Comments on this rule are actually due in a little over a week, and so I want to make sure that you are aware. Not going to change the slide yet because I pulled out the actual CMS fact sheet related to the contract year 2024, quote unquote, policy and technical changes for Medicare Advantage. And when you look, and we'll talk about some of these in a minute, but when you talk about some of the things that they address in the fact sheet, they are looking at things related to timely access to care and utilization management, marketing requirements as it relates to Medicare Advantage. This is going to be really getting into some of the spokespeople for Medicare Advantage products, etc. The star ratings program and health equity. So these were some of the things that from a fact sheet perspective focused on, but you got to get into the rule itself, and you come into some information in the rule that I think has caused some concern for a lot of providers. And this perhaps is geared for the compliance folks out there, and to think about the impact of this on your organization. But essentially, kind of hidden, I have to say, in this rule are some modifications to the regulations for reporting and returning Medicare overpayments. I think that you are familiar with the fact that historically, and I think this goes back to probably the Affordable Care Act, we had what we called the 60-day rule that essentially gave us as a provider, we were to use reasonable diligence to identify overpayments. I basically said that we would expect that a period of investigation would run about 6 months for you to go and identify any problems once there is a concern. And what they have done in this proposed rule is they've moved to remove the language associated with reasonable diligence and adopt the False Claims Act definition of knowing and knowingly. So it really moves us into a world under this proposed rule that if you have identified an overpayment, then you have actual knowledge of its existence, and that's where you then need to be making a repayment within a 60-day period. So I have to be very honest and give credit to King & Spalding. This was in their health headlines on January 3rd, and I thought it did a great job in terms of identifying the current standard versus the proposed standard. What they are attempting to do is line up Medicare A and B, which is what we've had with this reasonable diligence, and Medicare Part C and D, Medicare Advantage and Medicare prescription drug program. And for Medicare Part A and B, historically it has been a person has identified an overpayment when the person has or should have, through the exercise of reasonable diligence, determined that the person has received an overpayment and quantified the amount of the overpayment. What they are now proposing to do is to use the language, a person has identified an overpayment when the person knowingly receives or retains an overpayment. That's significantly different. It doesn't allow you the time for quantification and to look at, are there additional claims? I think on the previous slide, we said that the comments on this were due February 13th. While there's some other provisions I'll touch on in a minute that you might want to comment on, at least from a compliance perspective, you all need to be commenting on this revision to the 60-day overpayment rule. I think it's something that a lot of people might have missed because it was in a Medicare Advantage rule, which is Medicare Part C, and here they are revising an overpayment rule that applies to Medicare A and B. Anything on that one, Marty, before I go to some of the other provisions? Okay. Some of the other provisions that were included in this policy and technical changes for Medicare Advantage, and these are much more focused, but again, I think these are fairly positive for providers, is that they want to address some of the policies that the Medicare Advantage plans have that currently restrict or delay access to care. And one of the big issues that we have had in the past is prior authorization. There is a prior authorization rule that has been proposed that we'll address in a minute, but this one also looks at prior authorization. And it says that under the rule, this particular rule, there has to be, if prior authorization is required and given, then that prior authorization is going to have to be valid for the entire treatment period that is prescribed by the physician. What does he feel this is going to take? And then that prior auth is going to have to cover that entire period. For a newly enrolled Medicare beneficiary who is on an established treatment plan, then prior to enrollment, then that Medicare Advantage plan is going to have to allow a transition period for that patient, for their coverage to be in place, and then at a point later in the future to review whether or not coverage should continue. But at least for the established treatment plan, they would have to adopt coverage. And then for making medical necessity determinations, this is huge because a number of providers ask, does the Medicare Advantage plan have to follow the rules of fee-for-service traditional Medicare? Under this proposed rule, yes, those Medicare Advantage plans would have to adhere to the Medicare coverage policies for making medical necessity determinations. So this, I think, is a huge win for providers.
Kathy, one area I think for comment on this, because we live in formal policy coverage determinations and then a heck of a lot of sub-regulatory guidance that we receive from CMS through MLN articles or even in the preamble to proposed and final rules. I think this is a great opportunity for comment, that to the extent those rules are applied by the MACs in determining coverage for certain services, that should also be applicable to MA plans, because in particular, where I hear this over and over again is in this space of care management services. As CMS has developed up coverage for chronic care management and remote monitoring in the traditional space, we work with a lot of sub-regulatory guidance to figure out how to do that compliantly and get claims paid by MACs. And we often have the question of, are the MA plans going to be applying the same rules? So I think this is a great place for comment to say that sub-regulatory guidance should be just as applicable to the MA plans as well.
Absolutely. And look at your national coverage determinations, your local coverage determinations, and the consistency that needs to be in place for the Medicare patient and for those trying to do authorizations within your organization. So comments due February 13th. Get them submitted. I think this becomes one that comments need to be from a clinical care management perspective. They also need to be from a compliance perspective as it relates to the overpayments issue. So you might even be looking at writing 2 letters just to separate the topics. The next rule that we're going to talk about, again, published a little bit earlier on December 13th. And this is, let's talk prior authorizations again, but this was the advancing interoperability and improving prior authorization processes. Now this one, we've got a longer comment period. This one, comments are actually not due until March 13th. But we're going to focus just a little bit on what they are proposing as it relates to prior authorization. Previous rule that we talked about addressed prior authorization and adhering to some coverage policies from a Medicare fee-for-service perspective, the fact that a prior authorization needed to be in place for the duration of the treatment plan that was outlined by the physician. Well, under this rule, what they are saying is that essentially they are establishing timeframes for both standard and expedited prior authorization requests. If it is an expedited prior authorization request, the plan is going to have to respond to you as to yay or nay within 72 hours of the request. And if it is a standard non-emergent type authorization, then they have 7 calendar days to request. Calendar days, not business days. That is a huge issue because usually we talk in terms of business days. Recognize that this particular rule would apply to your Medicare Advantage organizations as well as your state Medicaid and children's health insurance, fee-for-service and managed care programs. This is huge in terms of the scope that this particular rule would have. Even more important from a patient care and communication with the physician who is ordering the care is that if a request for a prior authorization is denied, the plan is going to have to give a specific reason for denying that prior authorization. And this is where we get into a little bit more complexity with this proposed rule, is that there would be provider incentives for using electronic requests, using certified EHR technology. This gets into the interoperability issue and why this is both a prior authorization and an interoperability rule. If you are using an electronic means to communicate your request for authorization, then you're going to be dealing with some incentives related to additional response times and things like this. Martie, anything on that one?
Yeah, I think there's something interesting in this rule with regard to interoperability, which I think the provider community may have read right past it because it's the payer-to-payer standard. And you tend to think interoperability, there's talking about technical requirements, but the payer-to-payer requirement is focused on the obligation of health plans to secure data from other health plans regarding a patient. So as you know, those of us under age 65 change our health plans as much as we change our shoes sometimes. And it's problematic for providers because you're not getting a longitudinal record from any single payer. They only know about you from that time period that you're covered by that plan. So to address that, CMS is proposing that plans be obligated to acquire and share information about patients as they move from plan to plan. And it's going to be a requirement. The effective date, I think, is January 1st, 2026. That's what's proposed for the effective date, is that if you move to a health plan, that health plan then has an obligation to notify you that you may request that they secure information. It's going to be your basic, your claims and encounter data, no cost data, and then any prior authorization requests.
So that they can continue that prior authorization
right
for a period of time.
Yeah, exactly. So this is sort of, it's not going to, it's not exactly impactful on providers because it's an obligation being placed on payers, but think of how much, hopefully some of these things will go better if that plan actually has a longitudinal view of that patient. You do, certainly as the provider, but now the plans are going to start thinking about those patients in a longitudinal manner. And I think it's just also encouraging because plans are going to have a greater incentive to manage patient care, or at least to be engaged in management of patient care effectively, as opposed to it simply being a cost savings opportunity, because they're going to see the whole patient as well. So it may be pie in the sky at this point. I think anything with a compliance date that's 3 years out, we sort of wonder and are concerned about how it's going to go forward. And certainly it's impacting the payers, and I'm sure they'll have some stuff to say about this. But it's just, I think, encouraging that we're starting to look at interoperability as actually a vehicle to get to a longitudinal record.
Well, and I think also the thing that this rule tells me is that there were comments that were requested. There was an RFI, request for information, last year from providers related to issues surrounding Medicare Advantage and particularly with prior authorization. Many of you responded to that. You provided the horror stories in some cases in terms of the issues that impacted some of your patients. They listened to you. CMS listened. I mean, there was concern that this was going to have to be a legislated issue related to the prior authorization process, but it does seem like CMS, HHS listened, and that they are trying to make some improvements in the operation of the Medicare Advantage program to the benefit of both the providers and the patients. So kudos.
Yeah.
Let's go to the next rule. Again, this was a little bit longer length of time in terms of comments. This was the December 21 Federal Register short little rule related to the adoption of standards for healthcare attachments, transactions, and electronic signatures. Now, this is one that there will be a lot of work put into, comments being due on March 21. I know that the National Uniform Billing Committee and the National Uniform Claims Committee have established work groups to address how should we comment on this. And going back to the very beginning when we talked about the No Surprises Act and the delay in the comprehensive good faith estimate that included downstream providers, this rule is going to have some play in there, because again, we're talking about how are you communicating with downstream providers. The other place that this rule is going to have to come into play is that other component of the No Surprises Act related to you as a provider giving the payer sharing the information that the patient has signed a waiver to be balance billed or consented to be balance billed, providing the payer with an estimation up front of what the cost is going to be, so that the payer can then come back with an advanced explanation of benefits. This is prior to services being rendered. The adoption of these new standards for transactions and attachments going to have to come into play before we can ever move forward into that new process, new world that we need to be in. So under the issues related to, I think I went too far on the slide. Hold on. Yes. Well, hold on. Okay, okay. The idea is, it seemed like they had moved a little bit differently. The attachments rule, the focus is to improve communications, make them both more effective and reliable between providers and health plans. They do address both solicited and unsolicited documents. A solicited document is when a health plan requests information in order to adjudicate a claim, and then an unsolicited document is going to be when you submit a claims attachment to a payer without them having to ask for it up front. So it will address both types of documents that you would be submitting to a payer or a payer to you. The rule does include a proposal to move from the 50-10 transaction standard to the 60-20 for referral and referral certification and the authorization transaction standard. So this means that you as a provider are also going to have to move forward with a more current transaction standard that you would have to implement and adopt within your organization. This proposed rule would apply to the claims and the prior authorization. So it's the submission of a claim and additional claims information. It is also submission of information to support a prior authorization. It would apply to all health plans, clearinghouses, and providers. It's going to be voluminous. It's going to be all of your various products. It's not just going to be Medicare Advantage. It's going to be all of your commercial products, your Medicaid products, etc. And then last but not least, what this rule does is that it does define an electronic signature in a much more expansive way than what we currently have for the definition of an electronic signature. It could be a sound, a symbol, or a process that is attached to the transaction. So it will be much broader. I think it will be easier in some instances, but again, this could be a new process from a systems perspective going forward. Martie, any comments before I turn it over to you for
just a question. Just a question, Kathy, on this rule in particular. Granted, we're talking proposed rules, so everything is written in pencil. But what are they proposing in terms of compliance dates on these types of changes to the transaction rules?
Essentially, I have not seen anything from a compliance date perspective in the rule. They are really focused on getting feedback. I think anyone who's been involved since we've moved to the electronic health transactions world knows that these things take a while because there are various processes, systems have to be revised, etc. So this whole process will take a while.
Yeah, so HIPAA passed in 90. Yeah, I was going to ask you, HIPAA passed in 96. When did we have the first transaction and code sets in place? Like 2000, wasn't it, at least?
I think it was later than that.
Yeah, it's a slow process, but
it's a slow process
because it's a consensus-based process, and that's part of it too. We don't just...
Absolutely, and that's why I mentioned that the National Uniform Billing Committee, National Uniform Claims Committee, they will be responding and providing information. But you've also got X12 and the various other committees that are even more in tune to this. So I would say those who want to follow this, be talking to your Cerner, your Epic, your other systems folks to find out their feedback on what's going on.
Yeah, and for that future IT budget, right? As we have these updates to our EHRs to comply with these standards, right?
That's very true. We're going to turn it over to Martie now for a very interesting topic on non-compete.
Non-compete. So we've been talking about our good friends, Center for Medicare and Medicaid Services. We're going to switch gears and talk about the Federal Trade Commission and the rule it published on January 19th that kind of sent shockwaves across the business community. This is not a healthcare specific rule, but it would certainly have impacts to healthcare providers. So let's see if on this rule, comments are due March 20. I was peeking at it earlier because when you go online to the Federal Register, during the comment period, there's a clicker that shows you how many comments have been submitted to date. And this was already up in the thousands, not surprisingly, because this is going to grab a lot of attention. The unfortunate part is the clicker disappears after the close date. So you never really know how many comments were submitted and being able to access them. So let's see if I can figure out.
And I do just want to call the attention, it is non-compete, not non-complete. So
are you kidding? It wouldn't be a webinar without a typo, right? Exactly.
That's true.
So what is a non-compete? For purpose of this rule, the FTC calls a non-compete, it's a contractual term between an employer and a worker that's intended to block the worker from working for a competing employer or starting a competing business within a certain period of time, within a certain geographic area after a worker's employment ends. And typically the employer makes the case for securing a non-compete to protect the investment that they make in a worker. So if a practice hires a new doc just out of school and they're paying that doctor while he or she builds the practice, and then the doctor after 2 or 3 years says, yeah, I'm tired of that, I'm going to terminate my employment and I'm going to go start a competing practice. And so the practice's interest when they hire the doc is to say, yeah, we'll support you, but we don't want you to take the investment we are making in you and then turn it around and become our competitor. So we put a non-compete in an employment agreement. Not uncommon, not at all. Be sure you understand the difference between a non-compete and a non-disclosure or non-solicitation agreement. It is very common, for example, in my world as a consultant, that our employment agreements say that I am prohibited for a period of time after leaving the firm from making communication with firms for whom we provided services during the term of my employment, because I don't want to be developing relationships with clients to the benefit of the firm and then trying to take those out the door with me and build my practice that way. So that's the non-disclosure, non-solicitation agreement is getting after the same issue, but it's simply prohibiting you from using what you acquired during your employment to then become a competitor, as opposed to just saying you can't become a competitor. Non-competes are sort of a patchwork throughout the nation because state courts have applied different rules to non-competes, and state legislatures have also gotten into the mix. And so in any state in which you attempt to enforce a non-compete, you're looking at state statutes, case law, trying to decide when are non-competes enforceable. And in many states, it's a test of, is there a legitimate interest to be protected by the employer? And that's, obviously a fact and circumstances determination that becomes a source of a great deal of litigation in many cases. In other states, again, they are just outlawed by statute. So it's pretty all over the map. And it's interesting that the FTC, as its sort of federal authority, has decided to step into the ring on this. What the FTC is concerned about is the anti-competitive impact of non-competes. You see here 2 quotes from the proposed rule. So you definitely understand FTC's angle as they walk into this issue, that they think it's very anti-competitive, it artificially reduces wages, and that there's a lot of harm to the labor market that is going unchecked. In fact, that, for example, if you're in a state where it's a legitimate purpose test, if you're an employee who's cut off because of a non-compete, are you really in a position to litigate that with your former employer? And so that, of course, resorts, according to the FTC at least, is resulting in distortions in the marketplace. So their solution in the proposed rule is to define an unfair method of competition, that if you enter into a non-compete, if you maintain a non-compete, if you represent to a worker that they're subject to a non-compete, you as the employer are engaging in an unfair method of competition that violates Section 5 of the FTC Act and rains upon you the enforcement provisions that are attached to that particular statute. Note that FTC defines, I've been using the term worker, I've not been using the term employee, because workers defined to include employees, but also independent contractors, interns and externs, volunteers, apprentices, and sole proprietorships that are providing services to a client. So it's a very broad definition of worker when you can employ, would be prohibited from employing a non-compete. FTC proposes that the effective date of the rule be 60 days after publication of the final rule. The actual compliance date would be 120 days thereafter. That is very relevant because, first there's an exception. Let's talk about the exception. They do say that a non-compete is appropriate when you're dealing with the sale of a business or substantially all of a business's operating assets. In those circumstances, the buyer wants to protect the value of their purchase. And so the FTC creates an exception and permits a non-compete, provided the individual from whom you're trying to secure the non-compete is a substantial owner. And then they turn around and define substantial owner as one that holds 25% or more of an ownership interest in that business. Those that have less than 25%, though, cannot be subject to a non-compete. So take, for example, if you're buying a physician practice with 5 physician owners and they equally own 20%, you can't secure a non-compete from any of those stocks because they own less than 25% of that business. Now, to the importance of the compliance date, it's the rescission provision, because there are a whole lot of competes out there right now that are governing workers. So what are we going to do with the non-competes that are in place currently? And that's the rescission provision of this proposed rule, requiring employers to rescind any existing non-competes, both for current and former workers. So the folks you got now under non-competes that are currently working for you, those that have left and are working through a 2 or 3 year non-compete, this rule, rescission rule, applies to them as well. You are required as an employer to actively inform workers that their non-compete is no longer effective and cannot be enforced against them. And that should be provided through a notice in an individualized communication. That we need this to be a record trail, so it needs to be in writing or by email. And it needs to be provided within 45 days of actually you rescinding the activity. So you've got basically effective date is 180 days following the publication of the final rule. You're going to have 45 days after that to be sending out these notices to anyone for whom you have a non-compete. They provide for you a notice, a model language of notice, and it's a safe harbor provision. If you send this notice out to people for whom you have non-compete, you're deemed to have complied with the requirements of the proposed rule. So you can see here the very clear language that the FTC proposes that employers use. It's a model, but it's a model attached to a safe harbor. So we know how that works. You'll want to follow the model so you ensure that you're not subject to any sort of enforcement activity. The big issue here, as we look at the healthcare space, is the not-for-profit organization issue, because the FTC Act limits the FTC's jurisdiction to business entities that are organized to conduct business for a profit. And so the FTC does not have jurisdiction to enforce the FTC Act over not-for-profit organizations. They're generally deemed exempt from these requirements. So if you are a not-for-profit hospital, you employ docs, and they have non-competes in them, this proposed rule would not impact you. However, there's always a however, right?
Absolutely.
Yeah, if you are actually employing those docs through a subsidiary that's a for-profit entity, or you're a part of a JV that's organized as a for-profit entity, FTC has generally taken the position that it can go after those under the FTC Act, that they can reach that subsidiary, that JV that's actually itself a for-profit entity. So if you've cleverly organized your organization so that docs are actually employed under a for-profit entity, their physician venture, for other reasons related to tax compliance, appreciate that now the FTC issues that may potentially come into play under this proposed rule.
Marty, before you go on, let me ask you a question about that. You said on that slide that okay, I'm looking for it. Not-for-profit organizations generally considered exempt from the FTC Act. My gut feel, okay, first of all, using that word generally, yeah. I mean, I am assuming that some people might ask for clarification of this and their comments on this rule.
Absolutely.
I wonder if we really want them to clarify for what the answer might be.
Well, I think the clarification goes around these subsidiary relationships, the JV relationships. That's where the generally language comes from.
Okay.
And again, FTC has said, no, we can go after those in other contexts in enforcement of the FTC Act. And so, yeah, it is one of those careful what you ask for situations when it comes to comments. But trust me, everyone is caught. This rule is garnering a lot of attention in the market.
Well, I would think those individuals who worked for a not-for-profit organization and are subject to a non-compete, but are trying to go somewhere else, they might comment,
right,
in terms of maybe it should be applicable.
Yeah, and if you've read any of the business rags since this rule came out, I mean, all the big businesses saying this is beyond the FTC's jurisdiction.
Right.
And so even if the rule is finalized, I would anticipate we're going to have a round of litigation on this as well. But it's very interesting. The FTC is willing to go out here and say this because even without the proposed rule, you know, what they're trying to accomplish with the proposed rule is proactive, right? They're trying to prevent employers from doing this. They may just be, you know, they may be just putting a stick in the ground saying, we're prepared to challenge an employer So they can still bring their enforcement authority against an employer and say, we believe you've engaged in anti-competitive behavior. And so they're trying to do, sort of pay and chase, right? After the fact, they're going to seek the enforcement activity. The rule's intended to be proactive and say, you never can do this. So it's sort of interesting. What are they attempting to accomplish here? But clearly saying that they view these as anti-competitive and that it would be very challenging to ever be able to prove there's a legitimate interest, at least from their perspective on this. Request for comment, as FTC says, we've written the broadest rule possible. Tell us how we could potentially bring it in, such as should senior executives be exempt from the rule, or should they be subject to some sort of rebuttable presumption like legitimate interest? Should low and high wage workers be treated differently? Because it's very hard if a person's, not in management to try and enforce a non-compete against them. Should we also extend non-competes to franchisees and franchisors, for example? And really, what are better ways that employers can be protecting their interests, such as the use of non-solicitation clauses, and they can protect the value that they invest into employers. So there are lots of opportunities for comment here. Just specifically, some healthcare provider issues. I was really interested in the proposed rule never talks about what I think is the most significant issue in the enforcement of non-competes in the healthcare space is patient choice. That if you enforce a non-compete against a physician, they have a panel of patients and you're effectively preventing those patients from seeing that doctor. And that I think has come into play in a lot of litigation. And it's an issue I think that's really important to be addressed in the healthcare space. There's some really interesting physician comp issues here because you will have fair market valuations of physician comp that has assigned some value to the non-compete that is part of the employment relationship. Now, it's typically not formulaic. It's not 3-year non-compete equals 20,000 in comp. But our evaluation team had a good conversation with one of our evaluation team members about this and said, well, yeah, we could take it into consideration. If we're trying to figure out, does a salary represent fair market value? It's always a facts and circumstances analysis. And if there is a non-compete involved, that is certainly relevant. Well, if the non-compete's off the table, what does that do to those FMVs that have been secured on those comp models? There's also the issue that in some instances, a hospital will buy a physician out of a non-compete, that they'll pay out, oftentimes there's a liquidated damages clause associated with non-compete clauses. So if you choose to violate your non-compete, you have to pay us $100,000. Well, a hospital will sometimes pay that on behalf of the physician to secure them staying then in the community for a period of time, and they'll carry that as a forgiveness over time. They'll carry it as a receivable. Well, what happens to those receivables if those non-competes are no longer enforceable? Remember, current or former employees. And then that issue I mentioned previously about the sale of business exception at 25%. If you're buying a practice any larger than that, that's going to create an issue as well. So enough on non-competes. Let's talk about conscious rights. Okay, talk about a political hot potato. This rule was published at the beginning of January. Comments are going to be due on March 6th. It is quite a tortured history of what CMS has attempted to do, or HHS, excuse me, this is Office of Civil Rights within HHS. There are a number of provisions in state law, in federal law, kind of all over a patchwork quilt of provisions that that prohibit discrimination against providers who refuse to participate in services for which they find both religiously or morally objectionable, from abortion to assisted suicide, for example, and many things in between the two. But none of those provisions that prohibit discrimination against that worker actually have a direction to HHS to create implementing regulations. So in 2008, think of the time frames here. In 2008, the rules were actually proposed and finalized in 2007, near the end of one administration change. You had a rule that came out that created a system for the Office of Civil Rights to investigate complaints and take enforcement action related to violations of the conscious rules. In 2011, another administration comes up and says, well, we don't like the 2008 rule, So we're going to rescind it and instead come up with a much more streamlined process for enforcement activity. 2019, another administration comes back and says, no, we think we want to go back to sort of the 2008 framework. So we want a much more aggressive enforcement activity around this, a more well-defined process and requirements imposed on providers to protect their workers. And so now in 2023, another administration comes up and says, no, we really want to go back to the 2011 rule. So can you say political hot potato back and forth on this? So what we have then now in the proposed rule is an attempt to, quote, strike a careful balance between the patient's right to receive care and the healthcare professional's right to have their religious or moral objections respected. And what they effectively do is say, we're going to go back to the 2011 rule, but there were things we liked in the 2019 rule in terms of enforcement activity. We liked the broader definition of what constituted a conscious provision. So we think there's protections under war statutes. We like this idea of OCR having an investigatory process and how they will take action if they believe that they have identified a violation. We like the idea of OCR having a voluntary process to resolve those matters, to establish policy and procedure within the provider on a going forward basis. And we also like this idea that providers need to furnish notice to patients and workers about these rights. And we believe it's best practice for those to be, sort of the formal written notice, like the HIPAA notice of privacy practices, all these NSA notices and the like. So we'll see what's going forward. Again, if you look at the counter on the number of comments, it is also already in the thousands on this rule. So this garners a lot of attention. It is still just the agency trying to figure out how do we balance between the two, and do we favor one side over the other? But it's an interesting rule of which we should be paying attention to.
Martie, quick question, and I'm sorry to throw this at you, and you can just tell me, go away.
I'll turn your mic off, Kathy. So go ahead.
Okay, that would work too. How would this interact with state laws?
Well, they're federal statutes. And
okay.
The federal statute on which they're relying for this, the protection of the conscious right is in the federal statute. So federal statutes enforced by federal courts. Typically, there may be some, federal preemption under some of these rules or the like. But certainly, I mean, the state can impose a different standard. It can impose a higher standard. And so if it affords one protection over another. So yeah, thanks for another complicating layer to what's already a very complicated.
Anytime, glad to help.
Last rule we're going to cover is one for which the comment period has already expired. We apologize, but this is the confidentiality of substance use disorder patient records. This was a rule published by CMS, not by OCR. Again, Office of Civil Rights got this one because that's the HIPAA agency, but they published this in early December. And I think it's again an example of, oh, you thought this was about substance use disorder? Oh, wait, just a minute. There's a few other provisions in this rule. So for those of you that swim in the HIPAA sea, you know and have suffered through the inconsistency between HIPAA and 42 CFR Part 2. Part 2 is the regulations that govern the confidentiality of records that are generated by individuals or entities that provide substance use disorder diagnosis, treatment, or referral for treatment and receive some form of federal assistance, i.e. payments. We refer to these as Part 2 programs, but they are not programs. And these are just, if the language was modern, and it's not modern, this is an old regulation, but if the language was modern, it would use the term substance use disorder provider. And that's the groups they're getting at as opposed to some sort of formal program, okay? The problem with Part 2 is it was never reconciled with HIPAA. And while HIPAA governs how a covered entity uses and discloses protected health information, right? So it's the obligations on the covered entity, not protections attached to protected health information. Part 2 regulates the records that are created by the SUD provider. So it attaches to the record. It's not just regulating the SUD provider, meaning if a covered entity that's not a Part 2 program acquires these records that were created by an SUD provider, they are now subject to Part 2. So they attach the record and follow the record. If I, for some reason, ended up with SUD records, I would be subject to the rules in Part 2, as opposed to being, subject to HIPAA via a business associate agreement. So it's very complicated because the rules in Part 2 are far more stringent than what HIPAA requires. One issue that has been created as a result of this is that SUD providers have faced significant challenges in being able to access complete information, because what typically happens is, we all know how to do a HIPAA authorization form. We don't know how to necessarily do a Part 2 consent form, and a Part 2 consent form is specific. It only applies to that specific use or disclosure, and you have to acquire a new one every single time. So in the CARES Act, in the middle of COVID, Section 3221 said, hey, OCR, please reconcile Part 2 and HIPAA and make them work together. And so now in this proposed rule published in December of 22, OCR finally said, well, here's what we propose to do with it. What the proposed rule would do is eliminate the single patient consent rule and instead have a process similar to what we have in HIPAA, which is the authorization for use of disclosure for treatment, payment, and healthcare operations. It would permit the disclosure of Part 2 records consistent with the HIPAA privacy rule with a few minor exceptions. It creates new rights within Part 2 to allow a patient to obtain an accounting of disclosure. There are some Part 2 programs, because they never submit claims for payment, they operate on grant money, they aren't covered entities under HIPAA. And so part of what OCR is doing here is bringing HIPAA protections into Part 2 to reach those particular types of SUD providers. It also applies HIPAA civil money penalties, HIPAA breach notification rules. All of that is coming into Part 2 as well. And then modifies Part 2 confidentiality notice requirements so that they look like HIPAA notices of privacy practices. So again, the idea being these non-covered entities that qualify as Part 2 programs would effectively now be subject to HIPAA. And rather than simply making them subject to HIPAA and changing the definition of covered entity, they change the rules within Part 2. But it's the next slide that should capture your attention, because this rule also includes proposed changes to the notice of privacy practices, beginning with the fact that if you are a covered entity that receives Part 2 records, you have to provide additional notification in your notice of privacy practices with regard to Part 2 records. Well, every provider has the potential of becoming the recipient of Part 2 records. And thus it effectively is changing the content of the notice across the board for all covered entities. But more importantly, this rule resurrects a proposed rule that OCR published back in January of 21, which would incorporate even more changes into the notice of privacy practices. It would revise the standard header to include additional disclosures so that what's all in type in bold at the very top of your MPP is going to change. It's going to require that you designate a contact person and provide their email and telephone number so that if a person has questions about the MPP, that they can contact them. It changes the rules with regard to right of access. Because now, as Kathy made reference to, we've got new rules that permit an individual to request that their records be transferred electronically. We're going to change the description of the right of access in the notice of privacy practices to make patients aware of that right. But there's some really good news here. If they could please get this done, because I was excited about it in 2021 when they proposed it 2 years ago, eliminating the requirement to get a written acknowledgement of receipt of the notice of privacy practices. They proposed to eliminate this requirement and eliminate the record keeping requirement. So I'm sorry that the notice period has passed, so you can't cheer on OCR their attempt to get rid of this, but hopefully we will see a final rule published here, because of course there's a statutory mandate that OCR changed the Part 2 rules, that they're going to finalize this rule at some point, but this they hopefully saw as a vehicle to make those changes to the MPP. The question then, of course, is what happens to all the other provisions that were in the January 21 proposed rule? Suspect that maybe we're going to see finalization of those at a later period of time, or maybe a republication of them at a later point in time.
Martie, there is actually this is just going to complicate things even more.
Go for it.
Because I looked real quick to see where we were. Do we have a final rule sitting out there that, there is actually another proposed HIPAA rule that went to the Office of Management and Budget last week, January 26th. But this is a privacy rule related to reproductive health care policies. So it seems like more and more HIPAA proposed rules without final rules coming out.
Right. Again, appreciate what Kathy's referencing to is a proposed rule that's sitting at OMB, so it has not been released to the public yet. So OMB is doing its scoring
there for review.
Yeah, there for review. So maybe it includes the rest of the January of 21 rules. We'll just have to wait and see. What we need maybe is an omnibus rule.
But it's a proposed rule, so it's going to be another proposal.
Right, right, exactly. Go through that process. The enforcement date's important here because they're providing a long road here. That there'll be 24 months from the date of the publication of the final rule that you have to come into compliance if you're a Part 2 plan or if you're just a covered entity and the like. There is still some tolling on the effective date of the accounting of disclosure provisions that was proposed in a December of 2018 rule that has still not been finalized, which is intended to streamline the accounting of disclosure process. So we're waiting for that. So keep your eyes open, HIPAA privacy officers, HIPAA security officers. I think this may be the year where we get some of the resolution of these issues. Okay, one more thing to cover before we let you go. Kathy and I had to record this webinar in advance due to scheduling conflicts. And then lo and behold, there's yet another new development regarding No Surprises Act on Monday evening. The Federal District Court in Texas issued another opinion in Texas Medical Association versus HHS. This is the litigation regarding the independent dispute resolution process. The court ruled in this opinion that the new regulations that CMS published last year regarding the considerations that the IDR entity should take into account in deciding the appropriate payment amount. If you recall that initially the first version of the regulations said there's a rebuttable presumption that the qualifying payment amount is the appropriate payment rate. When that was overturned, CMS came back with a new rule saying, as we refer to it, QPA first, then all the rest. So start with the QPA and then take into account other factors. Now the court has said, nope, that's still inconsistent with the statutory language. So it vacated the provisions of the regulation that established those considerations for the IDR entity. So now going forward, absent a third regulation out of CMS, the IDR entities will be taking into consideration the statutory factors as they deem appropriate. So in their experience, being able to weigh those factors and determine what the appropriate payment amount will be. Of course, that leaves the question, what happens to prior IDR determinations that were made under the regulation that's now been vacated? I think that's a wait and see for now. The other news last week, which I'm sure you didn't miss, was the Biden administration announcing that it did not intend to renew the public health emergency, and thus it will come to an end on May 11. So please join us on March 1st for our next Healthcare Regulatory Roundup webinar, where we'll discuss how to get ready for the end of the public health emergency. So Laura, back to you.
Thanks to our presenters, Martie Ross and Kathy Reep. If you have any questions, their presentation and contact information will be emailed to you, along with a recording of today's webinar. Also, if PYA can provide assistance with audit, tax, compliance, valuation, or physician services, please call or email us. You may also visit our website at pyapc.com For more details about our specific areas of expertise, or to subscribe to receive PYA insights, please remember to stay on the line once the webinar disconnects to complete a short survey. On behalf of PYA, thank you for joining us and have a great rest of your day.